Mr. Wright.
My Lords, this is an appeal pursuant to permission granted on the 30th of March this year from the appellant's conviction before Mr. Justice Henderson, sitting without a jury for offences of rape and indecent assault. A further charge relating to the appellant's possession of a firearm was withdrawn at the close of the Crown's case. My Lords have the original indictment at pages 147 and 8 of the electronic bundle.
Yes, if it assists you, we've had the opportunity, which we've taken advantage of, to read your respective cases and the judgments below. Thank you.
I wasn't going to go through it in any detail. Lord, can I just say we're very grateful to Mr. Lavis, who's the governor of HMP Norwood in the Cayman Islands, who's allowed Mr. Wright into his office at 6 o'clock in the morning to watch the proceedings over the internet.
Thank you for telling us.
Lord, rather rudely, I've ignored the question of representation so far. As my Lords know, I appear together with my learned friend Mr. Nicholas Dixie on behalf of the appellant. Although Mr. Dixie appeared in the Court of Appeal, he did not, I hasten to add, appear in the original trial in the Grand Court. The respondents, as my Lords know, are represented by my learned friends Mr. David Perry and Mr. Alistair Richardson, neither of whom appeared in either the Grand Court or the Court of Appeal.
Right.
Lord, by way of housekeeping, apologies, we've handed in this morning a recent authority, the case of Crawford, which Lord Hughes delivered the judgment a few weeks ago, and I think 3 of the board were present on that occasion. Yes. I'm sorry we didn't get in earlier, but we only came across it last week.
Thank you very much.
Lord, these are relatively short points, but ones of considerable importance not only in the Cayman Islands, but in other jurisdictions as well. As I already said, I don't intend to read out our written submissions or praise or anything like that. So what we intend to do is focus on the, seemed to us to be 2 significant points which arose both in the Grand Court and in the Court of Appeal, and deal preemptively with some of the points we anticipate will be made by the respondents.
Thank you.
By way of headlines, in the Grand Court, the trial judge completely failed to address the defendant as to his choice and the potential consequences of his failing to give evidence.
Yes.
In reaching his decision, he used the adverse inferences he had drawn in conjunction, we stress those words, and we'll look at them when we come to the transcripts in a moment. He used those the adverse inferences he had drawn in conjunction with the complainant, who is referred to as W, as evidence before finding him guilty. To use the phrase we use in our written submissions, those adverse inferences tipped the balance. It's a phrase which was also used by Sir John Chadwick in the case of Tommaso, which we'll come to in due course. We emphasise the word in conjunctions, as it is clear in our submission it was not W's evidence alone which persuaded the trial judge of his guilt. It was the adverse inferences together with her evidence. The advantage we have over this having been I'm getting it the wrong way around. The advantage this being a non-jury trial is that we know that he drew inferences adverse to the appellant.
Yes.
We can see no distinction at all, which is one of the Crown's points, between this being a non-jury trial or a jury trial.
Understand.
Because, well, I'll develop it later, it's like being a non-jury trial, the judge has to make his decisions and set them out, whereas the jury obviously don't. The Court of Appeal in the Cayman Islands, whilst accepting that the failure of the trial judge to warn the appellant amounted to an irregularity, we submit material irregularity, the court went on to say that the judge could, we submit that's the wrong test, could have reached the same conclusion without drawing the adverse inferences. In other words, they were not only applying, we submit, the wrong test, but substituting their view of the evidence, something these courts have repeatedly said should not be done.
Understand.
Section 35 of the Criminal Justice and Public Order Act 1994 was, when it was enacted, a relatively controversial piece of legislation and fundamentally changed the position where a defendant decided not to give evidence. It's worth noting, and we'll see this when we come to the actual statute, that the Cayman equivalent, section 149 of the police law, only came into force in the Cayman Islands in November 2010. So at the time of the appellant's trial, October 2012, it was still a relatively new piece of legislation and been in force something under 2 years. By way of contrast, and it's set out in our written submissions, page 102, by way of contrast, can we just remember the old direction which would be given to a jury where a defendant didn't give evidence?
Yep.
The fact that the defendant has not given evidence proves nothing one way or the other. It does nothing to establish guilt. On the other hand, it means there is no evidence from the defendant to undermine, contradict, or explain the evidence put before you by the prosecution. Section 35 is set out in the authorities at tab 10.
Yep.
Sorry, tab 11.
No, you're right, it's tab 10.
It's both.
It's
It's both.
Yes.
Do you actually want section 35 or do you want section 149?
Well, I was just going to say they're identical.
Right.
They just very briefly look at behind tab 11 at section 35.2.
Right.
And my lords have it there set out. This is the amended one, taking into account the juries
I see.
that can now, trials can occasionally now take place in this country
Thank you.
without a jury.
Yep.
So we've got that at section 35.2 behind tab 11.
Yep.
I'm not going to take my lords to tab 10, the original version. It doesn't help at all.
I seem to have left my copy of the authorities in my room. There isn't a spare bundle of authorities in there, is it?
Well, Mr. Dixie's volunteering his.
Sure.
Time.
Oh, no, it's all right. You've got one here.
Saved.
Thank you very much indeed. Thank you. Yep.
So for my lord's note, the current version of section 35.2 is behind tab 11, unless my lords want me to read it out.
No, that's fine.
It's clear and well known.
It is right, is it? How far it takes anybody, I'm not sure, Stuart, but neither in section 35, whether originally or subsequently, or in section 149, is the adverse inference subsection, which is 3, made expressly dependent on the warning 2.
Now, I accept that.
Where that takes us, I'm not at all sure, but it is the fact, isn't it?
It's a fact, but then, with respect, I don't think it takes us anywhere.
No, well, I
We
anticipated
have
that.
what we have.
Yes, well,
Can we ask rhetorically, what is the purpose of the inquiry in front of a jury where there is one? The answer we submit is to ensure that the defendant knows the possible consequences of not giving evidence. And when it's a jury trial, that the jury know that he is aware of the possible consequences.
yes, in advance of that, of course, it's to ensure publicly that he knows that he can give evidence.
Yes, I'm sorry.
Well, it's not necessarily.
I've jumped a step.
Yes. There are two purposes. One is that he can, and secondly, what might happen if he doesn't.
Yep.
But we submit it, the purpose is obvious. It's for the defendant to know of the possible consequences. Whilst we accept, prior to the 1994 Act, judges could, in the appropriate case, make comment on the defendant's failure to give evidence, the old authorities, which are in the bundle between tabs I think it's 13 and 15,
Yes.
Don't, on our submission, help the court at all.
Understand.
Similarly, the old Cayman law prior to the 2010 police law, whereby inferences from a defendant's failure to give evidence could be drawn, they're set out between tabs 3 and 6 in the bundle. Again, our submission don't help. The police law of 2010 provided a completely new test. We submit, before we look very briefly at section 149 of the police law, that the complete failure by the trial judge to say anything to the defendant must, we submit, be a material irregularity.
What was the... Are you going to come to 18B and 18C at some stage, Mr. Wood? And if so, do it in your own time.
Yes, Anne.
But it would help us to know
Well, it's a
what
two-stage...
it meant before section 149 came into force.
I'll come to that.
Okay.
The complete failure to say anything to a defendant must, we submit, be a material irregularity coupled with the situation when adverse inferences are in fact drawn.
Well, just going back, you said that the obvious purpose is a twofold one. First, to ensure that the defendant is aware of possible consequences. And secondly, that the jury is aware the public warning having been given. The second point seems to me to be self-evident. But I wonder about the first, because there are all sorts of things in the course of a criminal trial which may have consequences one way or another, which is a reason why, on serious charges, defendants have properly qualified legal counsel. We don't ordinarily have provisions that the judge has to satisfy himself that the defendant has been properly advised as to the consequences of this, that, or the other. Before this provision came in, there was no requirement that the judge should ask him if he was aware of the common law consequences of not giving evidence. And since we rely, ordinarily speaking, on competent legal representation to tell the defendant what the score is, why is it obvious that this enactment was designed to ensure that in this respect, unlike anything else, the judge has to satisfy himself that the defendant knows, as distinct from the jury?
Well, my lords, we submit that is clear from the looking at the wording of, in the Cayman Islands Authority section 149.2. And if one also looks, as we'll come to, the practice direction in force in this country, which was also applicable, it's accepted in the Cayman Islands at that time, if one looks at the wording of both those in our submission, it is clear that it's the judge who has to satisfy himself that the defendant is aware. Because as my lord will have noted, when what actually happened in this case is that neither prosecuting counsel nor defence counsel seem to have had the adverse inference point in mind at all. The only person who seemed to think of it was the trial judge. But I'm going to come on to that, my lord, in due course. Because I'll illustrate it briefly now, if I may, my lord. When prosecuting counsel was reminded of the adverse inferences, she apparently said she was going to deal with it in her submissions, her final submissions to the court, didn't at all. And my lords will see in due course from the discussion that she provided no help at all to the trial judge, nor did defence counsel. Anyhow, could I just take my lords briefly to section 149, which is behind tab 8.
Yes.
At page 247. And my lords will see it's in virtually identical, I think in is an identical term to section 35(2). Where this subsection applies, the court shall, at the conclusion of the evidence of prosecution, satisfy itself, that's where I get assistance from, in the case of proceedings on indictment with the jury in the presence of the jury, that the accused is aware that the stage has been reached at which evidence can be given for the defence, that he can, if he wishes, give evidence, that if he chooses not to give evidence or having been sworn, without good cause refuses to answer any question, it will be permissible for the court or jury to draw such inferences as appear proper, etc. So, my lord, certainly our reading of section 149(2)
Yep.
is where we get that support from.
Yep.
Where's the practice direction?
Practice direction, my lord, is behind tab 12.
Yep.
This is an English practice.
This is the English practice
Doesn't
direction.
exist in the Cayman.
No, but it's accepted, and I can take my lords to it, that it would be applicable.
Well, counsel said no doubt the same practice would be adopted, but insofar as it prescribes, or rather, I say prescribes, advises specific wording, that has no force at all in the Cayman, has it?
Well, my lord, in fact it does, because if one turns up tab 7, the Criminal Procedure Code, and looks at section 113,
The parties contenders, yes. Well,
Yes, thank you.
and my lord, this was accepted, as I'll show my lords in due course,
Okay,
by the Crown and the Court of Appeal.
very well.
So practice direction
Yep.
to answer Lord Clark's questions behind tab 12, paragraph 44.
Yes.
At the conclusion of the evidence of prosecution,
Yep.
requires the court to satisfy itself, again, similar wording, that the accused is aware. And if one goes to the sub-paragraphs, 44(2) doesn't apply if there's a conclusion of the evidence of prosecution. The accused legal representative informs the court that the court will give evidence. 44(3), if the court is not so informed, or if the court is informed that the accused doesn't intend to give evidence, the judge should, in the presence of the jury, inquire of the representative in these terms: have you advised your client the stage has now been reached, etc., and if he chooses not to, etc. If the representative replies to the judge that the accused has been so advised, then the case will proceed. If counsel replies that the accused has not been, then the judge will direct the representative to advise his clients of the context and should adjourn briefly for the purpose before proceeding further. So, my lord, we submit that looking at all the section and the practice direction, it is the judge having to satisfy himself that the accused is aware. My lord, I know the respondents make a point in their written argument that section 149 provides no sanction for a failure.
Yes.
I'll only make the point that neither does section 35 of the Police and Criminal Evidence Act.
Right.
But it is a fundamental point.
Yes, it's, as the cases show, it's a familiar problem that statutes provide for something to happen, but don't tell you what should occur if they don't happen.
My lord, can I take my lord to the appeal documents?
Yes, of course.
I know my lords have seen them, but just to flag up what actually happened in court.
You'll take this fairly quickly. Because
Yeah, I will, my lord.
We have taken this on. We have read this. Yep.
My lord, can I draw my lord's attention first of all to page 78?
Yep.
No, in fact, 77. Whilst we're on this page, can we just note that, in fact, sorry, my lords, if one goes back to page 74,
Yes.
you'll see that at the end of the Monday, the 29th,
Yes.
the defendant was indicating that
Yes.
he was going to give evidence.
Absolutely. Yep.
On page 76,
Yep. next
see
day.
that overnight he's changed his mind.
Yes, indeed.
Now that is
Spoken
important.
with my client, thought about matters, instructions, he does not wish to give evidence, yeah.
We submit that is important because if the defendant had been in a state of indecision, it is all the more important that he is given the correct warning and warned as the consequences. And then at the bottom of 77, the court for the first time mentions adverse inferences. Over the next 2 pages, I'm taking this very shortly in view of my Lord's comment. Over the next couple of pages, the court is expressly inviting the prosecution to help him, and she provides none at all with respect.
You say warning, but really, strictly speaking, the judge is inquiring about the advice that's been given to the client by his counsel.
I'm sorry, my Lord.
But strictly speaking, the judge isn't giving a warning to the accused. He's inquiring of counsel whether counsel has given advice to the accused.
But he doesn't even do that.
But that's what he's required to do. I was just picking up the term warning that you.
Perhaps I'm using a word rather loosely, which is always inadvisable. My Lords will see over the next 10 or 11 pages there's discussion between the judge and defence counsel, who provides probably even less help to the judge. It's page 83.
I mean, this is all on the basis that the argument was that he shouldn't draw the inference on the facts.
Yes.
He's already given his account to the police. Why should he be required to give any more?
That's
That's
it.
what counsel says
I said
several
that
times.
Yes.
Yeah.
But it doesn't really go much beyond
No,
that. The judge at page 83 identifies the 2 points which he eventually accepts as the points he was to hold as being supportive evidence, namely that he was hiding under the bed and the breaking of the door. If one then goes on to the judgment, which begins, the important part begins really at 97, the judge says there's nothing in W's demeanour to suggest she's lying. He then goes on over the next few pages, 98, 99, to set out various points which he says support her case and don't support her
Yes.
case. It's not by all means one way. There are 2 particular points
Yes.
which he says detract from her credibility. And then the important part of his judgment really begins at page 108.
Yes.
Just at the top of 108, he says the lack of a fingerprint on either knife, and the inconsistency between the recent complaint or evidence about feeling a gun tend to erode her credibility. Overall, he says, I am satisfied that her evidence and the other points I have mentioned present in the aggregate a prima facie case. So he says setting the groundwork for being able to draw the inference. But then I'm not taking it up at line 20.
Yeah.
This defendant did not testify. If there was an innocent explanation for the broken door frame, he could have testified and said so. If there was innocent interpretation to be placed upon his actions at the time of the arrest, he could have said so. The natural inference, and the one I do draw, is that the defendant considers that giving evidence and subjecting himself to cross-examination would not assist his defence. When I consider that inference in conjunction with all the evidence in the case, I find that I'm sure W did not consent, so finds him guilty of both counts.
Yep.
Lord, that's really the crux of the first point.
Understand.
He's saying it's not W's evidence alone. And as I've already mentioned, and apologise for repeating, as this is a non-jury trial, we have the benefit of seeing him spelling them out, which you wouldn't have had if it had been a jury trial.
Understand.
Lord, can I turn briefly to the Court of Appeal? The Court of Appeal's judgment begins at page 149.
Thank you.
The appeal was heard on the 4th of April 2014, and the written judgment was released on the 24th of October.
Yep.
Can I just refer my lords to one or two paragraphs in that judgment? At paragraph 11 on page 155 of the electronic bundle, the court refers to section 149.2, and we note the wording used by the court. Section 149.2 makes it imperative for the court, at the conclusion of the evidence of the prosecution, to satisfy itself, which we emphasise, in a jury trial in the presence of the jury, that the accused is aware that the stage is reached at which he, if he wishes, may give evidence. Further, that if he chooses not to give evidence, stripping out the unnecessary words, it is permissible for the court or jury to draw such adverse inferences as would appear proper for his failure to do so.
Yep.
Paragraph 12, taking up 3 lines into paragraph 12, that before the court or jury may draw such inferences, the court is required to ensure the accused is aware that the stage of the proceedings had been reached at which he may give evidence. We emphasise required. If I can just continue reading to the end of that paragraph. At which he may give evidence, and if he chooses not to give evidence, it's permissible for the court to draw such inferences as appear proper from his failure to give evidence. In addition, he must be told that if he gives evidence and without good cause refuses to answer questions, the court or jury may draw such inferences appear proper from his failure to give evidence. Lords, we'll just note in passing that Mr. Dixie drew the court's attention to the practice direction, which we looked at a little while ago, and the section of the Cayman law, section 113, makes that applicable. And my lords will note at paragraph 15, Miss Hutchison submitted that there is no equivalent practice direction in the Cayman Islands. She accepted the practice would likely be the same if a direction was given on this section. That's, I hope, dealing with my Lord Hughes's point earlier, drawing those bits together.
Thank you.
Paragraph 18. In this case, Mr. Justice Henderson, page 160.
Yeah.
Mr. Justice Henderson was sitting without a jury. He had a duty to ascertain from counsel who appeared at trial whether he had advised the applicant of his right to give evidence and the consequence of his failure to do so. It's imperative, word used again, the judge fulfills the duty placed on him. In this case, the court cannot be satisfied the judge did conduct the inquiry which he ought to have done.
What way of putting it?
Paragraph 20, in the opinion of this court, the failure of the judge to carry on the mandatory duty placed on him amounted to an irregularity in the course of a trial. But the further question has to be determined is whether the irregularity was such as to make the trial of the applicant unfair and the conviction unsafe. Can I then jump on, please, my lords, to paragraph 25?
Yes, of course. Thank you.
This is the crux
This
of
is the crux, yeah.
Yes. In our opinion, there was evidence in which the judge could have reached the conclusion that the applicant was guilty of the offences without drawing the adverse inferences.
And you say that's a self-misdirection.
Yes.
Understand. The vice is in the word could. Yep.
Lord, can I take the courts very briefly through some of the authorities?
Well, can I just ask you one question? Could we go back to the moment when this point was first discussed? What page was that on?
83? No, sorry. But raised by the judge, says my lord.
Yeah, when he was first told what the position was, when the judge was first told what was...
But that he wasn't giving evidence.
Yeah.
Page 76, my lord. Thank you.
Yeah.
Yeah.
I mean, one of the curiosities of the case is that the judge did directed himself correctly as to what the position was under the section, including the second limb. And the only thing one could say in his favour, perhaps, was that he must have drawn an inference from what was said at page 76, lines 10 to 12, that part of the discussion between counsel and his client must have included that warning.
Well,
Otherwise, he couldn't have directed himself in the way that he did. So what were they discussing if it wasn't that very question? Because we all know that he'd been told, he knew from the day before that the client knew perfectly well that he didn't have to give evidence because that was what he was considering overnight. And so one asks oneself, therefore, when he says here, I have spoken with my client and he thought about matters overnight, the inference the judge must have drawn, you may say wrongly, was that he was given the appropriate warning.
except that's
Because
one-
otherwise it doesn't really make any sense.
Well, except that's
What
one-
he did doesn't fit together at all.
I accept that's one interpretation, but in our submission, it's
say we
even
can't be
more,
sure.
even more important. With the judge at the end of day one, he's saying he's going to give evidence.
Yeah.
Beginning of day, he decided not to. A sort of umming and ahhing. Even more important that the judge satisfies himself that the defendant, as he then was aware of the possible consequences. The statute is quite clear. It's for the judge to satisfy.
Right, my point is that the judge must have satisfied himself from what he was told at line 11, exiguous though it is, that was the position. Otherwise,
Well, it's unfortunate it's not on the transcript.
well, I follow that.
Another way of looking at that, I suppose, is a point of construction which I must put to you because it's in my mind, although I'm not at all sure there's anything in it. If you look at section 149.1 on page 247, after A and B, it says subsection 2 doesn't apply if at the conclusion of the evidence prosecution his attorney at law informs the court the accused will give evidence. Well, he did. At the end of the hearing on the first day, he said he will give evidence, and then he changed his mind. Now, it might be said that on that basis, the judge knew, because he'd been told by counsel, that the defendant knew he could give evidence because he was going to. And therefore, subsection 2 doesn't apply at all.
Well, Lord, that's very hard reading
Yes.
of section 149. When one looks at the transcript, you see quite clearly the following day.
Well, I know, but the point is that given that part of the reason, at least for subsection 2, is that the judge is aware that the defendant knows he can give evidence. Clearly he knows he can give evidence if he says he's going to give evidence, even if he changes his mind. Now, if he changes his mind, maybe, picking up Lord Clark's point, the natural inference is that he knows the consequences. So it may be that once you say, I'm going to give evidence, the fact you change your mind doesn't result in the disapplication, in the removal of the disapplication of subsection 2. I put that forward as a argument which is, I have to confess, only just occurred to me. Maybe absolutely nothing in it, but it's right, it should be aired.
Well, thank you for airing, my Lord. There's nothing I can say about it, save that if a clear reading and looking at the purpose of section 149 or 35 in in England and Wales, makes it a very hard ruling.
Well, it doesn't, because if you say, my client is going to give evidence tomorrow morning, the judge can be in no doubt that the client knows that he can give evidence. So at least the first half of section 1492 is satisfied.
Yeah, but not the second part.
Well, the second
Certainly
part,
not aware of the consequences.
That is the possible flaw in the argument.
But it does matter
It is the
what
co-
you can infer from the conversations that there were. Now look at 74 first.
Yep.
And just before we look at the text, your case, as I understand it, is the purpose of section 149 is to ensure publicly that the defendant knows two things. First, that he can give evidence if he wants to. Yes? And secondly, that if he chooses not to, he takes a risk.
Yes.
Right. Well, now, looking at 74, was the judge entitled to infer or not that the defendant knew that he was entitled to give evidence?
Yes.
Quite. So,
Well, I think,
it's all right. I'm not suggesting you've ever suggested otherwise. I just want to follow it through step by step. That much is quite apparent, isn't it, from that exchange? Yes?
yes.
The question that Lord Clark asked you is whether the combination of that and the following page 76 does or does not carry the inference that he has spoken to his counsel about the decision first.
There's that possibility, my
He
lord.
must have done, mustn't he?
Well, I have spoken with my client, and he thought about matters overnight, and he gives me instructions this morning. He doesn't wish to go in the
Right. So that they have that at least something has passed between them about whether to give evidence or not is or is not, in your submission, a legitimate inference.
It is an inference, but in order for that inference to carry any weight, you would have to have then he does appreciate the consequences.
I know that's what you say, but I'm trying to test it out. You might be right, but I'm just trying to find out why. The first question is why can't you infer from the fact that they've clearly had two conversations, not one, one before page 74 and another one before page 76? Why should you not infer that counsel has told him what the law is? Well, there must be. You presumably have to say you can't be sure of that.
Well, you can't. Well, that's what I do say and have said.
Yes, I see. All right. Now, is there any significance for the later Court of Appeal, or for that matter the Board here, that there is no evidence or even assertion from the defendant that he didn't understand the position?
Lord, it's different from some of the other cases, but in our submission, that is a bad point.
Because?
With respect.
Because?
Because the Court of Appeal, the Court of Appeal didn't seem to occur to them at all that there was any such discussion.
I'm asking you.
Lord, I can't say that there is.
I'm sorry, you can't say that there is anything. There is what? You say there's no significance at all in the fact that he doesn't even assert that that his conversations with his counsel, which he clearly had, did not include what on the face of it would be the absolutely orthodox advice. You don't have to give evidence, you can if you want to. If you do, you'll be cross-examined, and if you don't, then there's at least a chance that the judge will hold it against you.
Well, that would mean the defendant, and I know this is raised by the respondents in their arguments, effectively waiving his privilege.
No, I think there's a different point here. We can't accept, draw an adverse inference from the fact he doesn't waive privilege. But surely we can, along the lines that Lord Hughes is running, assume, we are entitled to assume, that everything that should have been done was done.
Well, my Lord,
In the absence of any evidence to suggest the contrary, isn't it justifiable for a court to assume that the counsel will do their duty?
my Lord, we would submit no, because if one looks at the exchanges between the judge and both prosecuting and defence counsel, it's quite clear that they were flapping around, if I can use a very rude phrase, to deal with the concept.
But that was on the footing that the question was whether the decision had been made that the inference could be drawn. And the question was then whether the inference should be drawn. Struck me that a more critical moment, or possible, certainly a part of the analysis which we look at, is the judge's approach when he explained that he was going to draw the inference. Now,
81.
81, yes.
Sorry, I think
No, I just couldn't find the page.
the court's question on page 81, I think. You said you were going to address this failure to give evidence, but you haven't done so. Perhaps it's somewhere else. Sorry.
Well, he identified the 2 points, didn't he, the judge?
In his final judgment, yes.
The point that struck me, anyway, there may be nothing in this point as well, I quite follow that. The point that struck me was that
It's
he...
page 79, sorry, towards the bottom of 79. Okay, you're not suggesting I should refrain from drawing an
And that's counsel for the Crown.
Oh, yes.
I mean, the thought that occurred to me was that in the light of what had happened the day before, and the defence counsel's statement that there had been some discussion, query what, with his client, the judge must have thought that he'd given the warning. Otherwise, on the judge's own analysis, he couldn't have referred to it, because he referred in the course of his own judgment to the 2 prongs of the test. So he couldn't conceivably have thought that there hadn't been some such discussion. Otherwise, he couldn't have said what he did. Now, you can say that just shows how wrong he was, and that's what I think you have to say. And you may be right about that. I'm not saying you're wrong.
Lord, I do submit with respect, my Lord is wrong. And section 149 makes it quite clear, if you look at the wording of it, that the judge is fundamental for the judge to do so. The Court of Appeal recognised that. The Court of Appeal in the case of Tomasa, which will come to in due course, had no difficulty in deciding that was a material irregularity. But the same judge did exactly the same thing.
I mean, as I understand the argument, you say that it's completely immaterial to what advice may or may not have been given by counsel. The statute requires an inquiry by the judge. The absence of such an inquiry is an irregularity, and one must treat it as having been Parliament's intention that such an irregularity would be taken to have resulted in a miscarriage of justice, subject possibly to the proviso.
Lord, I'll grasp with gratitude my Lord's words, because that is exactly the point I was trying to make when caught in the crossfire from the left. And my Lord,
Yeah, I mean,
it's worth
you say that the language of 1492 is inconsistent with the judge being entitled to draw an inference that the person has been properly advised. The explicit statement he will give evidence doesn't require any inferences. That is hard evidence that he knows he can give evidence. But you say, since the court is under a duty to satisfy itself, that can't be fulfilled simply by an assumption that counsel has told him.
Yes, it's a firm duty on the court to satisfy itself. When one looks at the words of the practice direction as well, there's support from that as well. But my Lord, can I just remind that at the time the 1994 Act came into place, the police caution changed.
Absolutely.
And it's to take into account failure to mention when interview. Is this court really saying, well, he was represented by a solicitor or in the police station, the solicitor must have told him that the caution had changed, and if he didn't answer questions, could be all sorts of trouble? Or a failure to caution, is my Lord, was this board really say that answers given after an old caution when the new one should have been given, or a no caution given would be admissible? It can't be right with respect, and it's a proper analogy.
Can I ask you a slightly related question? Under the practice direction, the court is required, in certain circumstances, ask defence attorney whether he has given certain advice to the client. That's an exception from the normal approach, where normally speaking, a court can't ask defendant's counsel about the advice he's given. Would there be anything to prevent the judge, when it came to the colloquy about whether to draw an inference, from asking the same question? Did you advise your client?
Lord, I know some judges, and when I've been concerned, when I've been sitting, I've been concerned at the slip representation. I've been known to ask the defendant directly, have you been advised?
No, I mean, a question. When the argument took place about whether the judge should give an adverse inference, and the judge was asking counsel any reason why I shouldn't, would there been anything to stop the judge at that stage asking the question, did you give him the advice?
No, nothing at all.
So at that stage, you could perfectly well have asked him. Yes. Since he did explore with counsel what reasons there were for not drawing an inference, since counsel never said, well, a very good reason is you didn't give him the warning, the judge's immediate response would have been to say, well, didn't you advise him? And that you accept would have been permissible.
Yes.
Well, those sections, the only reason why the judge wasn't entitled to infer that he had been properly advised.
Well, my Lord, with respect, again I say yes.
Well, test it, Mr. Wood, by supposing that in that exchange that we have at 78, 9, 80, between the judge and counsel for the defence, as to whether he was entitled to draw an adverse inference or not.
78.9 is...
Isn't that
prosecution.
it? I beg your pardon,
Prosecution.
79.80. 79.80, 81. That exchange, which runs for several pages, test it in this way. If in the course of that, the judge had asked the question of counsel and received the answer yes, could you nevertheless mount an appeal?
Yes.
You say you could?
Yes, because of the wording of section 149, have you satisfied...
Yes.
And that's at the close of the prosecution case.
So you have to say that, don't you?
Yes.
So just to follow that up, so if the judge had said to him, well, didn't you advise your client? And counsel said, yes, of course I did. And he knew exactly what the score was, but that doesn't weaken my point in any way. In law, the judge's obligation was to say, well, you're absolutely right on that, and I can't draw the adverse inference. Even though the client knew that he had been given the advice about the adverse inference being available.
Of course, it wouldn't have been too late for the defendant to be called at that moment, before the speeches began.
No, it was at that point...
Because
my
all
Lord,
that had happened, the evidence came from there the night before.
the prosecution had made their submissions before the adverse incident. I think I'm right.
I'm not sure about that. Well, the point anyway was being discussed with the Crown.
Yes, you're right, 77.
Yes. So, my Lord, Mr. Dixie prompts me to the left. What would have happened then? This is why it's all speculation. The defence counsel, oh, no, I didn't. Completely forgot me. Completely passed me by. Seems to pass the Crown by completely.
No, I mean, the acid test is what happens if he says, yes, of course I did.
Well, then they
You still say that makes no difference.
because the duty, the burden is on the judge. Lord, can I move away from that? And I'm not going to go, as I said, through all the authorities. But if I can, I'm not going to refer the court to Cayman because it's so well known. Radford I do refer to for the wording used by Lord Justice Roche. It's behind tab 17 at pages 308 and 309. Bottom page 308, Lord Justice Roche. The importance of giving a proper warning to a defendant and proper directions to magistrates where a defendant doesn't propose to give evidence or doesn't give no evidence cannot be overemphasised. As the Lord Chief Justice has recently stated in Birchall, yet unreported, it's regrettable that in this case the appropriate steps were not taken. That failure constitutes an irregularity in the proceedings. Then he goes on to say, the question is whether that's material irregularity. In Radford, the court did not allow the appeal because it's quite clear that the magistrates remarkably weren't even referred by their clerk to section 35, and didn't draw any adverse inferences. But if one goes down a little further, the court knows that the magistrates did not have in mind, when considering their verdict, section 35, and drew no inference adverse to the appellant from his failure to give evidence. In those circumstances, I skip a paragraph, there's no material irregularity. But it's the words of Lord Justice Roach emphasising the importance, and I can't remember who gave the first judgment.
Mr. Justice Potts.
Yes, the provision is mandatory on page 307. But, my Lord, can I take my Lords on to the case of Tomasa and others, which you have the short judgment at paragraph 20, tab 27.
That's right.
And followed up with the written judgment at paragraph tab 28. This was a decision of the Court of Appeal of the Cayman Islands. And my Lords see the composition of the court. It was a decision only a few weeks after the written judgment had been given in this appellant's case. So what happened is John Chadwick said he'd give us a short written judgment because it was a pending retrial, and he refers section 9.1 of the Court of Appeal law, paragraph 2 on page 497, requires that subject to section 12, the court shall allow appeal of conviction if he thinks there was a material irregularity in the course of the trial. In the present trial, there is no doubt that there was an irregularity in the course of the trial. Going on to tab 3, halfway, about 7 lines down, page 498, at the conclusion of the prosecution evidence, the advocates representing each defendant informed the judge their client would not be giving evidence. So the law required the judge to satisfy himself in the presence of the jury that each defendant was aware that if he chooses not to give evidence, it would be permissible for the jury to draw such inferences as might appear proper to do so. And, my Lord, it's worth noting, and the counsel appearing for the appellants in that case, at least 2 Queen's Counsel from England, and Mr. Simon Dennison, Queen's Counsel, appeared for the Crown. Paragraph 4, in the present case, the judge did not satisfy himself in the presence of the jury, or as far as appears from tension at all, that each defendant or any of them were aware that if he did not give evidence, inferences might be drawn from his failure to do so. So coming back to the points my Lords were making earlier about inferences drawn that his attorney must have warned him, if you look at the lineup of those representing in those cases, it's with respect not a fair point. That, as I have said, was plainly an irregularity. It became a material irregularity because in the course of his summing up to the jury, the judge directed the jury that the defendant's silence at trial might count against them. Over at paragraph 5, a direction in those terms compounded to the failure to warn, that's a typographical error, it should be 149.2 in paragraph 5. A direction in those terms compounded the failure to warn under section 149.2 of the police law. A direction to the jury they could draw inferences from something exacerbated the very danger of which section 149.2 was intended to ensure that defendants were aware that when they remained silent. Mr. Dennison, Queen's Counsel, sorry, I can't resist the tease of Mr. Perry, that he and Mr. Perry are joint heads of their chambers, who appears for the Director of Public Prosecutions on this appeal, but who didn't appeal at the trial, accepts correctly, in our view, that the judge's failure to observe the requirements of section 149.2, taken with the judge's direction to the jury that they could draw inference from silence, constituted a material irregularity at this trial. Put shortly, it rendered the trial unfair. Well, my Lord, we do rely on the concession by the Crown in that case and the decision of the court. paragraph 9, I should also add this. It would be apparent from the brief observations that I have made that this is a material irregularity which should not have occurred. It would not have occurred if the judge had reminded himself of his duty under section 149(2). It is to be expected that it would not have occurred if counsel, whether for the prosecution or for the defence, had reminded the judge of his duty under that section. And it is to be expected that it would have occurred in the sense that what was an irregularity would not have become material for irregularity if counsel had pointed out to the judge that having failed to comply with section 149(2), he should not direct the jury that they might draw adverse inferences against the defendants. So having failed to give the direction, he shouldn't have, the only way to cure that was to not draw inferences. And we know that in this appellant's case, the judge failed to give the direction and drew the inferences. At tab 28, I only refer to, that's the subsequent written judgment in Tomasa and others, to note in paragraph 1 that it was the same judge who had originally held Tomasa who dealt with this appellant's case. And if one looks at those who appear, it appears to be the same prosecuting counsel, Miss Hutchison, who appeared again. So familiarity with revisions of section 149(2) should, with respect, not be assumed. Lord, we've included various other cases, one Randall versus the Queen, which the court will be all too familiar with, the words of the Lord Bingham, in summary saying, everyone, even the guilty, are entitled to a fair trial. Barlow we've included because it was referred to by Sir John Chadwick in Tomasa, who reviews, it's in...
It's the proviso test, isn't it?
Yes. But in summary, and I hope I'm summarising clearly, it's behind tab 25, that the court sitting on appeal should be very wary to substitute its view of the facts.
No, that won't do, Mr. Wood. The proviso requires the decision as to the safety of the conviction to be made by the Court of Appeal, Stafford and Lavalliere, all the way through. You can't shift, and there's nothing in Pendleton to say otherwise. See Dial. So once you get to the proviso, it's essential that the Court of Appeal looks at the facts. The question it asks itself is whether there's a reasonable possibility that in the absence of the irregularity, the jury might have come to a different conclusion.
The words, I think, are the inevitable result.
Well, reasonable possibility, inevitable is rather strong, because you can almost never say the jury couldn't do something. but it's quite that's why I wondered why you brought us Crawford. Because if you've brought us Crawford in order to address the question of when a Court of Appeal ought to readdress the facts of the trial judge, the answer is no, he shouldn't, unless there's got something gone wrong. Yeah. But when you get to the proviso, you have to, don't you?
I got the wrong way around, I apologise. My Lord, we're looking at Barlow, at paragraph 74, paragraph 492. Where they reviews the Australian and New Zealand authorities. According to tests laid down in Matenga, before it can apply the proviso, the board must consider that although there was a miscarriage, the guilty verdict was inevitable in the sense of being the only reasonable possible verdict on the evidence.
Yes.
That's the point.
Since re-explained by Lord Kerr in, for example, Lundy and Pora and one or two others from New Zealand. Yeah. That's right. But was it the only reasonably possible verdict taken overall? But it's a decision for the court. That's the point. Yep.
Then that gives you another back.
Well, my Lord, really our concluding point, I hope, is obvious from what we've been saying up until now. In our submission, there was an irregularity.
Yes.
If it wasn't a material irregularity per se, it became a material irregularity when the trial judge drew adverse inferences against the appellant. And given that we can see and have the advantage of seeing the judge's reasoning and thinking process, the verdicts are unsafe, as it by no means cannot be sure that on the evidence they're the only reasonably possible verdicts.
Well, now, if we get to the proviso, Mr. Wood, what do you say about that? Was there a reasonable possibility that this woman was lying? Because that's the only possibility, isn't it? It's either a lie...
If one goes back...
Hang on. Do you agree, first of all, it's either a lie or it's true? There isn't any room for mistake.
Well, I'm going back to what the judge said in drawing his judgment, taken in conjunction with.
I appreciate that, but if we have to confront the proviso, what do you say about it?
The judge has picked out a number of points which he says support her credibility, a number which don't support her credibility.
Well, he seemed to think that the absence of fingerprints in some way chipped away. Was it fingerprints or...?
It was DNA on either of the knives.
Why on earth does that chip away at her credibility? Well, does it?
Well, the judge found that he did,
Yeah,
and I wasn't present.
What's your submission, Mr. Wood? Does it or doesn't it?
Yes, it does.
Why?
Because that's the finding the judge came to, who, having heard all the evidence.
I see. All right. And what about the manner in which she gave her evidence?
The judge observed her.
Quite. He directed himself, as far as I can see, that her initial reluctance, which we've seen and read, we don't need to go through it, effectively had no bearing on her, on the likelihood that she was truthful one way or the other. Was that an inevitable conclusion?
Well, Lord, I can only keep going back to what the judge said. He said, I observed the demeanour of Miss Phillips closely while she was giving evidence. Yeah. Nothing about the demeanour suggested to me that she was lying. Right. He then goes through the points to, for and against. And his wording is clear. When I consider that inference in conjunction with all the evidence, I am sure. So if you strip out...
No, I've got the point that he relied on the adverse inference. What I'm trying to get at is whether there was an overwhelming case without it.
There was a case. There was certainly a prima facie case. I don't accept it was overwhelming, and I don't accept it as a proviso case.
And do you agree, last question, because I'm not sure that I've got the answer, is it or is it not a case in which it's either a deliberate lie or it's true?
My Lord, having not been present at the trial, it's difficult to give that answer.
Is it? All right, well, there we are.
Well, my Lord, Mr. Dixie reminds me, and I've already mentioned it, he did, at the beginning of at the end of the prosecution case, he did withdraw count one, firearm count, from the jury.
On the basis that she might be mistaken about that?
Yeah.
Yes. But when it came to the rape, anyway, there we are. You've given your answer as to what I shan't press it.
Thank you.
Can I just add one question to that? The judge was particularly concerned about the damage to the door when it came to drawing an inference. The case, of course, put to the complainant was that she'd invite him round, and this was a prearranged meeting with sex on everybody's mind. When she's cross-examined on those lines, page 41, she says, if I'd invited him, I'd have opened the door. There'd have been no need for him to kick my door in. Now, absent any innocent explanation for the damage to the door, what was the answer when we're considering the proviso to her point? If this was all consensual, I'd have let him in.
My Lord, I can't answer that. Neither Mr. Dixie nor I appeared for him below.
You're taking your position firmly on what the judge said.
Yes. Lord, I have to.
No.
That's because those are the reasons for him coming to the conclusion.
Of course. No, I understand that. And I'm not saying that accusatorily, I'm just saying it factually.
Thank you, Lord.
Thank you very much indeed. Mr. Dixie. Thank you very much.
May it please your lordships, my lords, we support the conclusion reached by the Court of Appeal. We submit that the failure on the part of the learned judge to follow the procedure and then go on to draw an adverse inference against the appellant made no difference to the outcome of the case. In other words, a guilty verdict was inevitable in the sense that the only reasonably possible verdict was one of guilty, and there's been no miscarriage of justice. Lord, we also submit that the failure to follow the statutory procedure is not a material irregularity. It does not involve any denial of procedural fairness. And, my Lord, we submit that it is important to understand the purpose that underpins the procedure. It is not intended as a warning or a threat to the accused. As my Lord, Lord Toulson noted, there was no such procedure before the 1994 Act came into force, even though comment was permitted by the trial judge at common law. The purpose of the procedure is not to warn the accused of the forensic consequences of silence. The procedure in a jury trial is designed to emphasize to the jury, or to the judge in a trial by judge alone, that the accused who does not testify has consciously chosen to remain silent and deliberately passed up the opportunity of defending himself in person in the witness box. In other words, it amounts to a public acknowledgement that any adverse evidential consequence is entirely of the accused's own making. It is not in terms of a warning. The statute does not speak in terms of a warning. And that is why we would submit it takes place in the presence of the jury. If it were simply, does your client know that he can give evidence and have you advised him, that could be done in the absence of the jury if it was simply for the judge to satisfy himself that the defendant knew what the potential consequences might be. And we submit that because it is not a warning, and because it is not intended as a safeguard for the accused, then any error to follow the procedure, even when coupled with the drawing of an adverse inference, is immaterial and inconsequential in terms of the eventual result, and it was not intended by the legislature to lead to the quashing of conviction. So in other words, my Lord, what we would submit is this, that if you're going to appeal in a case where a judge omitted to follow the procedure, which we accept is mandatory, but that doesn't solve the ultimate question of what is the consequence of a failure. If you're going to appeal on the basis of a failure on the part of the judge to follow the procedure, it must be coupled with an assertion, a positive assertion, and I did not receive appropriate advice. Otherwise, the courts are entitled to proceed, particularly in this day and age, that defendants are aware of the legal consequences of a decision to give, of a decision not to give evidence. So, my Lord, what we submit is the safeguard for an accused person is not in the mouthing of a mandatory formula. It lies in the advice actually given to the accused by his legal representatives.
In the case of the practice direction 44.3, this doesn't arise here, but it says the judge should inquire in the presence of the jury. Does your submission apply? I know you don't need this in the present case, but does it apply in a jury case? Or is it important, even if the judge knows the situation's okay, that the jury knows?
Well, my Lord, we would submit, my Lord, that whether it's a jury trial or a trial by judge alone, it's not a warning.
Why? It sounds like a warning to me. Why isn't it a warning?
Why then is it to be in the presence of the jury in 44.3 on page 260?
But, my Lord, the reason it's in the presence of the jury, we submit, is that it's the public acknowledgement of the consequences. Even before this legislation was enacted, you could draw adverse inferences in certain situations.
I understand that. If it was purely for the purpose of satisfying yourself, or satisfying justice, or satisfying the court, that the defendant knew the legal position, then you wouldn't need to do it in the presence of the jury.
Yes.
That's why I ask. It doesn't apply here, I appreciate, but why it's in the presence of the jury.
My Lord, we would submit, my Lord, the reason it's in the presence of the jury is because there is in the presence of the jury the public acceptance of the potential adverse consequences. So it is indicating to the jury that the defendant knows this is the position. It's not saying to the defendant, I'm warning you, if you don't give evidence, I'm going to direct the jury that they can draw adverse inferences. It is the public acknowledgement. And no doubt it was to ensure publicly that when the jury receive that direction, they appreciate that the defendant was aware of the consequences so that they're not left in any doubt in relation to that. But this is not a procedural safeguard, we would submit. It is merely a formula to ensure that publicly the position is known. If it were a safeguard, it wouldn't be necessary to do it in front of the jury or in open court.
How big a change was it?
My Lord, it wasn't.
Wait a minute. How big a change was it in 1994?
Well, my Lord, there are two answers to that question, my Lord. One is in the Cayman Islands, it was barely a change at all.
Well, that's a different one.
Yes, because since 1978 you could draw inferences.
Yes, we'll come to that.
I'm going to address you,
I
Lord.
rather understood you to be suggesting that it wasn't much of a change in England either.
Well, my Lord, in many ways, my Lord, if you look at the way Lord Taylor addressed this issue in Martinez-Tobin, in certain circumstances, this case would be one of them. The judicial comment could be strong.
Yes.
Because the case law, there were two streams to the case law. One is where you simply sat back, the Dr. Bodkin-Adams type case, prove your case. You haven't proved it against me. The other was, I'm putting forward a positive case. She consented. Yes. There's no explanation for the breaking of the door. In the latter type of case, judicial comment could be stronger because the defendant was positively asserting or advancing a case. Now, because of the way that the Court of Appeal identified the essential terms of the direction in the Cowan case, that there has to be a case to answer, that there can be no other reasonable explanation for his failure other than that he had no explanation to give or none that would stand up to cross-examination. But Lord, I would submit that in many cases the change would not be that significant.
Well, what's said against you, you better have the opportunity to deal with it, is it was a sea change.
Well,
made a huge difference to the practice of the criminal courts, and particularly those who defend it. And moreover, it said it was controversial, and that, well, I don't think Mr. Wood said it, this was part of the price.
Yes. Well,
now, you better have the opportunity to deal with those.
Yeah. My Lord, I fully accept, my Lord, that it was an important and significant change, not least because it permitted the prosecution for the first time to comment on an accused failure. Although, my Lord, it appears in the Cayman Islands, that it remains the case that the prosecution cannot comment, curiously.
Yes.
So, my Lord, it may be that that was legislative oversight because our legislation was curious to this extent. If you look at the trio of sections that permit inferences, whether it's to account for objects or evidence, silence in interview, silence in court, you then have to go to the end of the statute to find out whether the prosecution can comment upon it. I think from memory it was section 116 and then schedule 7, which didn't actually say the prosecution can comment, it simply amended the 1898 Criminal Evidence Act. But, my Lord, in the Cayman Islands, curiously, we would submit, the position is of more, certainly from a historical perspective, of more interest, because if I may just invite your Lordship's attention to divider 3, memory stick page 236.
Yep.
This was the evidence law in 1978.
Yep.
And your Lordships will see that from as long ago as 1978 in the Cayman Islands, section 18 provided at C, the failure of a person charged with an offence to give evidence shall not be made the subject of comment by the prosecution, but the court or jury may draw any reasonable inference from such failure. So whereas there was no provision of this type in English law, that was the position in the Cayman Islands. Now, my Lord, that provision, if we go to the next divider, manuscript page 238, was reenacted in 2004.
Yes.
The provision has been amended immaterially, but it's now 18b.
Thank you.
Exactly the same. But also, my Lord, it's still in force.
Yeah.
Because if your Lordship see divider 5,
There he is.
manuscript page 240,
There we get 18B.
we get 18b again.
Yep.
My Lord, this provision is still in force. It wasn't repealed.
Right.
Now, my Lord, if the learned judge in this case had said to the appellant, had said to the defendant, I'm not going to rely on section 149.2 because I've got to go through this palaver. I'm going to rely on section 18b. Is there anything you've got to say as to whether it would be reasonable or unreasonable for me to draw an inference? What would be the answer? The answer would be, it is not unreasonable for you to draw an inference that anyone engaging in consensual sex, having been invited to the complainant's premises beforehand, would not need to break down the door before engaging in sexual activity. Now, we would submit that this provision here exposes the fallacy in the argument, because the learned judge makes reference both to section 18 and to section 149.2.
So does the prohibition on the prosecution commenting upon these points apply to the other part as well as this?
My Lord,
So
as
the
I
prosecution
understand-
had no business making any submission at all.
As
And
I
the judge
understand-
said to the lady, well, what do you say about that, Miss So-and-so? She should have said, well, I can't answer any of that. See section 18b.
Well, but my Lord, it does seem odd that you
funny
can't
to
comment
me.
on either, because it doesn't appear as though that...
No, 18b, the comment by the prosecution referred to in 18b is surely comment in the course of the trial.
Yes.
I.e. to the fact finder.
Yes,
It's
yes.
not submissions to the judge, is it?
Yes, but my Lord, so far as the learned judge is concerned, he did. Perhaps I can come on to deal with it because I'm going to.
I mean, really, you're saying that there's nothing in section 149 that makes compliance with its requirements a condition precedent to section 18b.
Exactly, exactly, my Lord. Now, my Lord, does
Does that mean that how far does that get you? Does it mean that the judge doesn't have to comply with section 149?
Well, my lord, if a judge didn't rely on section 149 and relied on section 18, he wouldn't have to follow the procedure. And your lordships can see this at...
Wait a minute. Why isn't section 149(1) and 2 freestanding? Even if section 18b applies, why section 149(1) says, if at the trial of any person, subsection 2 and 3 shall apply. Why doesn't subsection 2 apply? Despite what section 8, why is that inconsistent with section 18b?
Well, Lord, only because the procedure seems to be linked to the section, compliance with the section itself. The learned judge made reference to this, my lord. If I may just invite the board's attention to page 103, where he says the evidence law provides for the drawing of an adverse inference when the defendant does not give evidence. The police law provides in somewhat different language for the same adverse inference. So
I can see what you... Sorry.
Well, I rather thought that perhaps section 149(2) doesn't itself provide for the drawing, a basis for the drawing of adverse inferences.
Yes. No.
It's rather ancillary to or parasitical upon section 18b. And what it's concerned with is the accused's awareness that it will be permissible to draw inferences, and you could read that as being it will be permissible under section 18b for the court to draw.
yes, yes. But Lord,
I'm not sure it really makes much difference. The question in the end is material irregularity and proviso.
yes. And my lord, what we would say, my lord, the reason why we rely on section 18b is, if it is to be suggested that this was a sea change, we would submit that so far as the Cayman Islands is concerned, at any rate, it isn't.
In the end, whether it's a sea change or not, the issues are ultimately the same, aren't they?
Well, Lord, it also, we would submit, reinforces the point that we make about the sort of advice that would be expected in a jurisdiction where since 1978
Yes, I see.
there was a provision.
Fair enough.
And any lawyer in a criminal case, what's the most important decision any accused person takes in a criminal case is should I answer this charge, and what are the forensic consequences if I don't? And we would submit that any court is entitled to proceed and safely proceed on the assumption that would be the advice that was given. But Lord, on the facts of this case, of course, I can deal with this very briefly. The learned trial judge raised the question of whether or not it would be appropriate to draw an adverse inference in the course of closing submissions, as the board has been told. And we make 3 points. There was no complaint at that stage about the failure to follow the procedure. Yeah. There was secondly, there was no complaint at that stage that the defendant had not been made aware of what the consequences of a decision would be.
And the matter was clearly flagged up by the judge.
Yes. And Lord, it could have been open to an accused in those circumstances to raise the point. Whether it would have been permissible to reopen the defence case is another matter. But we do not accept the contention contained. If I may just give your lordships the reference without referring to it. But paragraph 8 of the appellant's written case at MS page 205 is that the inference must be that had the appellant been warned, he would have given evidence. We submit that the inference is to the contrary. The inference must be that he was warned. And as a matter of common sense, as much as law, any defendant who doesn't give evidence, particularly having seen a complainant give clear evidence of criminal activity in this case, must have known that if he did not give evidence to contradict that account, there would be consequences. In relation to, may I just, the point I was making...
Does the judge direct himself that the defendant must have known that?
No, my lord, not.
And nowhere in the actual judgment
Because the judge,
does he say that. Indeed, the reasoning is very, very exiguous, right?
Well, my lord,
And there's a lot of setting out of these sections.
yes. My lord, we would submit that, in fact, on analysis, what the judge really concludes in his reasoning is that he accepted the credibility of the complainant, because there was no reason not to accept the credibility of the
Well,
complainant.
except for the bit relied upon by Mr. Wood, the top of page 108. And Mr. Wood says, well, it's all a balance, and he said that there were some factors which pointed against her credibility, and there's some points that point in favour of her credibility.
Well, I don't accept that there were matters.
Well, one of the audibility, I mean, the real question is whether she was telling the truth in relation to the rape.
Exactly.
The whole case seems to have been really, all this judgment doesn't seem to be so much about that at all. It seems to be mostly about what the explanation was for breaking down the door.
Yes. And but
Sounds to be, on her evidence, he broke down the door whether he was going into rape or not. I mean,
Yes.
done it before,
well,
when she was consenting.
Yes.
So there's something very odd about treating that as the critical point in the case.
well, my lord,
There we are.
equally, we don't accept, my lord, that her unwillingness to give evidence, as is apparent from the record, was not a factor in her favour. When you read it, she was. She didn't give evidence in any vindictive way. She was moderate in the way that she approached her account. Lord, so far as Martinez Tobin is concerned, the conventional direction at common law, may I just give your lordships the reference without turning it up because it's well known, but it's the Authorities Bundle Divider 15, see Lord Taylor, Chief Justice, at page 397 of the report between letters C to E, which is MS page 282, and the distinction in the case law between the bare denial type of case and the type of case where a positive assertion it was being made, and in this case, of course, it was not disputed that the appellant had forced his way into the premises by breaking down the door frame. That was not a contested issue in the case. See the record at page 54, where the complainant was cross-examined about what had occurred once the appellant was in the premises. Lord, may I just make very brief submissions about two authorities. First of all, Radford and Kent County Council, the decision of the High Court, Mr. Justice Potts and Lord Justice Roche. First of all, may I just invite your lordship's attention to page 308 to 309, because there was one aspect of the decision upon which we would place reliance. Page 308, behind it's divider 17.
yes, we've taken this passage. At the
Yes.
beginning of it anyway.
Lord, may I just invite your lordships to what Lord Justice Roche said at the top of the second paragraph, or the first full paragraph on page 309, the second sentence. No doubt before he decided not to give evidence, he was advised of the risks in taking that course. So there is no doubt before he decided not to give evidence, he was advised of the risks in taking that count. And I ought to point out that in that case, the appellant solicitor had made the appellant aware of the provisions. That's apparent from Mr. Justice Potts' decision at page 306, the penultimate paragraph on that page. And Lord, just one other aspect of at page 308, where Lord Justice Roche appears to
Well, that was a waiver of the privilege, was it?
Since the point was conceded, it doesn't get us very far, does it?
well, my Lord, I would submit, my Lord, that in every case you could make that assumption.
Yeah, but this case is based upon Mr. Watling's concession.
Right.
Yes.
Which amounts to a waiver of the privilege.
Well,
Then, my Lord, at page 308, at the beginning of Lord Justice Roche's judgment, there's reference to Birchall, which was a decision of Lord Bingham. That was not a failure to give the to follow the Section 35(2) formula. It was an omission to direct the jury on one of the essential preconditions, namely there must be a prima facie case before you can draw the inference. So it wasn't dealing with this particular point. We submit that Radford was the result should have been the same, even if the magistrates had drawn adverse inferences adverse to the defendant as a result of his silence. So we say Radford should have been decided in the same way, even if the court had drawn adverse inferences. Right. In Goff, which is Divider 18, page 312, my Lord, we would submit that here, although the Court of Appeal treated the failure to follow the procedure and the drawing of adverse inferences as a material irregularity, in fact, the case is better analysed as a case concerning a defendant who absconds during the course of his trial, and where a defendant absconds during the course of his trial, the specimen direction given to the jury is that his absence is not an admission of guilt and adds nothing to the prosecution case. So it would be highly inconsistent for the court then to follow the Section 35 procedure. So although the Court of Appeal, Lord Justice Kennedy presiding at paragraphs 16 and 25, MS pages, page 316 and 317, dealt with it as a material irregularity point on the basis of the Section 35 procedure, we would submit it's better analysed, although the court went on to apply the proviso, which was clearly the correct result. So, Lords, we would submit the Court of Appeal decision was correct in this case in relation to the eventual outcome. We submit that the decision in Tommaso is wrong insofar as it suggests that a failure to follow the statutory procedure, even when coupled with the drawing of an adverse inference, amounts to a material irregularity. We say that with respect to the Court of Appeal. It proceeded on the basis of a concession. The Court of Appeal did not investigate the purpose of the provision, and it did not consider the relationship between Section 18, the pre-existence of Section 18, and then the coexistence of Section 18 and 149(2). And our essential conclusion is that the circumstances would have to be extreme for the mere failure to follow the statutory procedure to amount to a material irregularity, and it would have to be coupled with a complaint that the defendant did not receive the appropriate advice, as was the position in decisions such as Faruqi, Authorities tab 20, paragraph 126, page 364. And, Lord, if your lordships go on to consider the proviso, we would submit that this is a classic case for an appellate court to reach the conclusion that the prosecution case was not answered by the appellant, and that the only reasonable and proper verdict was one of guilty, and that the court should dismiss the appeal. So, Lord, adopting what we've said in our written case, unless I can assist your lordships further, those would be our submissions in resistance to the appeal.
Thank you very much, Mr. Perry. Mr. Richardson. Mr. Wood.
Lord, Mr. Dixie is much more familiar with Cayman law than I am. He's trying to bring something to my attention. May I ask for 10 minutes?
10 minutes. We'll rise for 10 minutes.
Thank you, Lord.
If you want us back earlier, you can try and see if we can come back earlier.
My Lords, thank you for that.
Not at all.
Lords, can I make 4 relatively short points? Firstly, taking up what my Lord Clerk said, in nowhere does the judge who was the trier of the case say he must have known. He was aware of the consequences. That is not said either in the Court of Appeal, either in the case of Wright or in the case of Tomasa. In the case of Tomasa, it said is wrongly decided. We disagree. The concession we submit is a perfectly proper concession for them to make. My Lords have already noted the number of Queen's Counsel from England who appeared in that case. They were rightly told off by the Court of Appeal for not having brought it to the judge's attention, but nowhere there does it say, look at you lot, forgive the vernacular, are you trying to tell me that you didn't tell your clients the consequences? They rightly stuck to the wording of section 149.2. And if one looks at the wording of section 149.2, it is quite clear that that section is putting the onus on the judge himself to satisfy himself that the judge is aware of the consequences. As I made the point earlier during the course of argument, that not only did the section 100, sorry, the 1994 Act bring in the change, it also changed the caution in the police station, fundamentally. Now, would this board say that if someone hadn't been cautioned properly in the police station, that because he's represented, he must have been aware of the consequences? It's a circuitous argument, I know. And finally, on the proviso, I know I'm repeating myself, and apologies for doing so, but here we actually see, unlike a jury case, the way the judge was thinking. He clearly says, when I consider her evidence, in conjunction with the adverse inferences, I am satisfied. For that reason, we say this is not a proviso, because this board can't substitute its view of the evidence with the fact-finding judge's findings of fact on the law, on the case. He heard the evidence, he used the inferences to tip the balance. And it's interesting that the Court of Appeal in Tomasa, in paragraph 6 of the written judgment, used that exactly the same phrase. So we can't be satisfied that didn't tip the balance. Well, those are our short responses.
Thank you very much indeed. Well, we're very grateful to both Mr. Wood and Mr. Perry for making their submissions very concisely and clearly. Thank you very much indeed. We're also grateful to everyone involved in preparing the written cases that we found helpful. The board will take time to consider what advice they will humbly tender to Her Majesty. Thank you very much indeed. The court is now adjourned.